morning, everyone. What a pleasure it is to be with you. We appreciate everyone who has taken time to join this very early hour, 8 o'clock. As I looked through the registration list, I was pleased to see that we have over 100 participants who have registered for this webinar, representing various industries throughout Utah. I think that's because of the title of this webinar, very fitting title, The High Stakes Risks for Utah Companies Doing Businesses Overseas. My background is such that I took a company that I previously worked for, Franklin Covey, a Utah company with international ties to about 20 countries. And certainly there are high stakes and risks associated with expansion overseas. And we are so fortunate to live in a state where there are partners who we can do business with, trust, and who have deep capabilities to protect us and our company's assets as we're making high stakes decisions. Which is why we've decided to partner with Parsons Behle and Latimer, and grateful for their continued partnership. Mike Bailey on the team has been a member of our board at the World Trade Center for some time. Mike, we appreciate you and the team. And let me just tell you a little bit about what we do as a World Trade Center. Our goal is to be a convener of good businesses and partners with the end in mind that we will be able to provide the services that any company in any industry in Utah will need to expand and grow overseas. So I'm vice president of our Global Business Services division, and we have companies who walk through our doors on a day-to-day basis. And a lot of times companies will come to us and they'll say, hey, I want to go to India and do business. And we say, well, that's fantastic. Why India? And they say, well, because my mom recently was there on vacation. And we say, well, that's not a great reason to go to India. Let's take it 2 steps back and really walk you through a good process that will help you get prepared in terms of assessing your capabilities, your readiness, your preparation, your risk tolerance, et cetera, and then deliver some good market research so you can make an informed decision on behalf of your business. And then from there, we bring in great partners. Partners who have deep expertise in the services that they deliver. That could be website optimization, localization, translation, freight forwarding and logistics, and so forth. Today, we have one of those great service providers on the line. And in fact, I would like to turn the time over to Jeffrey Corey, who's going to introduce his team to us and explain a little bit more about what his firm is doing. Go ahead, Jeff. Thanks.
Great. Well, thank you, and thank you to the World Trade Center of Utah for giving us this opportunity. We have an interesting discussion about issues that really are, I think, very important to anyone who's operating internationally or considering operating internationally. And it's my pleasure to briefly introduce my colleagues who will be doing a bulk of the speaking today. We have Brent Baker, who's a shareholder here at Parsons Behle Latimer, where his practice focuses on SEC enforcement defense, securities litigation, as well as representing clients who are targets of government enforcement matters, both domestic and internationally. I want to note that Brent's experience is vast and would take too long to summarize, but that includes more than 11 years as an attorney with the U.S. Securities and Exchange Commission, where he regularly handled cases involving foreign conduct. The other panelist today is also my colleague, Eric Christiansen. Eric is also a shareholder at Parsons Behle Latimer, where he regularly defends businesses involved in commercial securities and financial litigation matters. He too has extensive experience in this area, including representing clients in internal investigation matters involving foreign conduct. And I'll just note my role here. I'm the moderator for today. My name is Jeff Corey, also a shareholder. My focus is similar to Eric's and Brent's, although with more of an emphasis on white-collar criminal defense, and I've had prior both government and private sector positions. There is one more participant in this. You see 3 of us up here on the screen. There's a 4th participant here that's not pictured, and that is all of you. All of you who are listening today, we very much want to be a participant, part of the discussion. And so here's what we're going to do. We have a feature, which you should be able to see on your screen. That's a chat feature. you are welcome and encouraged to type in questions. And look, I know this is not as ideal as back in the olden days when we could all meet in person, but we really want to encourage you, even in the middle of the discussion, to ask questions. And the reason for that is all of you have extensive experience. Maybe some of you have been through the kind of cases we're going to talk about. Maybe some of you haven't. Maybe you're contemplating certain business operations that might be relevant to these issues. So please interrupt. Our speakers like to be interrupted, and I will help you interrupt them if you type in some questions. We're also going to have a discussion at the end. We're going to leave time for some Q&A at the end. That doesn't mean you have to hold off on any Q&A, but we are going to allocate some time at the end for some questions and so for some additional participation. So with that being said, I think we should start first with Brent. I will turn over the microphone to you to take it away.
Hey, thanks, Jeff. And also thanks to the folks at the World Trade Center, Utah. They're well respected throughout the community, and they work well with GoEd and Silicon Slopes. So I appreciate the opportunity. We're here to talk about some of the risks associated with doing business outside the US. I suspect that many of you are associated with a company that either currently does business outside the US or would like to expand internationally to new markets. And of course, that's a rhetorical question, but you should be thinking about that. And since, as Jeff mentioned, we're all still relegated or mostly relegated to our home offices or our home kitchen tables, in these days of COVID, Zoom and WebEx have stepped up. My problem, though, with these digital formats or electronic formats is that real-time audience participation is so limited. Usually when we are speaking on a panel, we interact with the audience. That may make this presentation today feel a little sterile or antiseptic, and that wasn't a COVID pun. And I can tell if my jokes are falling flat either, just so you know. Jeff will get the questions to us, and there's also going to be a Q&A at the end. As Jeff said, I spent actually over a dozen years at the SEC, and I left the government private practice in 2007. I feel great honor in my service. I also clerked for a chief federal district court judge. And you know, my time at the SEC gave me knowledge of the rules of practice. And I kind of know what the line level attorneys are going to say before they say it. Now, that's a little too much, but I have been inside the belly of the beast, and I survived. Now, I don't want to leave Jeff and Eric out. They both have specialized and unique skills. Jeff, as you mentioned, was a federal prosecutor on the East Coast. Eric was the chair of the Utah Securities Commission when the governor appointed me to that same commission. And I was on the commission for 2 terms, about 8 years. And I couldn't survive without Eric's mentoring and leadership. I don't remember, Eric, how many years you were on the commission, but you rotated off, and I just don't remember. You were on there at least 2 terms. All right, so there are some topics we're not going to talk about, or I'm not going to talk about. So, for example, and this is all based on time, legal issues, regulatory issues, compliance issues that are imposed by other foreign governments on US businesses doing business in their country. The FSA in London, the BCSC, I mean, the British Columbia Securities Commission. I have been to Antigua met with their securities regulators. I've been to the British Virgin Islands and met with their securities regulators. So doing business outside the US is almost mandatory in what's left of the New World economy. Now, if you want a lawyer who's going to take you to the ballet, I'm not your guy. If you want a lawyer who will have your back in a bar fight, I'm your guy. And I know where the pool cues are kept. So, and by I, collectively we have a very team-centered approach in all of our different focus areas. But that leads me to the next point, and that is, I'm not sure how to advance the slides. There you go. Can you advance it to my first slide? Oh, I see the arrow. Okay, thanks. All right, so the critical issue is you need to be able to coordinate in this setting. And depending on the jurisdiction you're interested in expanding into, potentially there are 3 separate tracks that an investigation can go down. Civil regulatory cases brought by the SEC, criminal cases when they rise to a sufficient level of willfulness, and shareholder cases. And these all have to be seen together. So class actions, derivative actions, and Eric's going to talk about those, but all these things precede each other, but they come in close time proximity. You have to know that. All right. So what percentage? So the SEC is a regulator. They bring regulatory cases. And I'll go over very quickly what they can do, but I'll just tell you why you should listen to Jeff. A year or two ago, I was talking with the director of enforcement at the SEC, and he said, this is Rob Kazami, he said about 60% of the SEC's regulatory investigations are referred to the Department of Justice or a state level prosecutor for criminal prosecution. Now that's an important number, 60%. The SEC brings about 1,000 cases a year, 700 to 1,000, investigates 10 times more than those, but they can all proceed down parallel paths together. So this triple track investigations are sensitive and difficult. Now, do you have to be a publicly traded company for the SEC to have authority over you? And again, difficult to respond in this setting, but I'll tell you the answer is no. Let's think about how a company goes public. Is it when they file an S1 to register shares? Is it when they engage in a reverse merger or a reverse takeover? These are all complicated. It isn't settled. But let me tell you this fact pattern that'll probably ring true with some of you. So I'll pretend like I'm a cool new tech company CEO, and our company has an emphasis on the creative use of blockchain technology. I founded this company with my buddies, Steve, Bill, and Paul. We set up a business entity and we agreed that we were splitting everything 4 ways. Okay, so from the first capital contribution, we each got 25,000 shares. Are we at the point where the SEC has authority over you, your initial shareholders, both in the US and outside the US? Well, you don't have to be public, obviously. You don't have to be traded on an exchange for the securities laws to apply. So here's the actual question you need to ask when you're thinking about doing business overseas. Now, the question is, have you raised money from early stage investors in private or exempt offers or sales? You all have heard offering documents described as private placement memoranda or private offering memoranda. There are other related agreements like subscription agreements, but so you want to, you've already raised capital, you've got shareholders. So here's the question: is a security involved at all? Basically, the SEC has the ability to call a ham sandwich a security. I mean, the original test, as Eric and Jeff will tell you, is the Howey test. It was a case in Florida that involved selling fractionalized interests in an orange grove, and so it's a little murkier than you think. It's basically whatever the SEC wants it to mean, and all offers and sales of securities must be either registered or exempt. IPO is a traditional way to exit, but you also need to know another discouraging fact here, and that is that the SEC is not the only agency with regulatory jurisdiction here over US-based companies with subsidiaries in foreign countries, individuals, US individuals working in foreign countries for those businesses. So you've got, besides all the foreign regulators, you've got state securities regulators, which they also have the ability to examine and bring actions against participants in our capital markets, in our financial services system, and I think that the state regulators are more dangerous than the federal regulators. I mean, at the federal level, there are no articulated minimums or maximums. On the criminal side, it used to be back in the day when I left that if the losses were not more than $5 million, they wouldn't pursue the case. Now, circle back to the state. The state can bring a case for $5,000 or $1,000, and they can make it criminal by sending it to the Attorney General's office very quickly. So that's a little more dangerous. Now, Jeff, you've seen that same thing, I'm sure.
Very, very small state level criminal cases are common. It's just, I mean, I think the lesson is be very careful when you raise money and how you try to raise money. I've had one here in Utah not that long ago where it was petty how incredibly small the dollar amount was and the facts of the case were.
Yeah, I appreciate that. I'm sure Eric's had the same experience. But the bottom line is not whether you're a public company or not, or whether you're traded on exchange. The bottom line is whether or not you have issued either debt or equity securities to raise capital for operations. Basic threshold test. So quick primer on SEC enforcement. And I'll just tell you that I am not a huge fan of PowerPoint, because what often happens to me is I end up reading from my slides, which makes our panel even more sterile and antiseptic. So I'll try and keep.
I won't let you do that. Don't worry, okay. Brent.
I'm working on an outline. I occasionally will glance at the slides. All right. So the SEC basically, how do they select individuals in the U.S. or offshore to charge? You've got Office of the Whistleblower. You've got the TCR portal, which is tips, complaints, and referrals. And they can bring either actions in federal court or administrative actions. Now, shareholder actions like those that Eric's going to talk about, often, I have to say often, either precede or follow regulatory investigations or regulatory actions. Your legal team needs to understand how to coordinate all of these moving parts. The SEC has direct consequences to their actions. They can bar or fine you. They can have a judgment entered here, and they can have all the bars and disgorgement and civil penalties it wants to. And it's an interesting difference in doing business offshore, and that's because they would have to collect on that judgment. And as Eric will probably tell you, collecting on judgments by taking them to a foreign country and sort of domesticating them, that's a process that occurs with some regularity. So the indirect consequences are what probably are most important to this audience, and that is the damage from reputational risk, predatory short selling, loss of officers and directors insurance, loss of key employees, especially those in the compliance role. Right, so globalization is really the driver of expansion to foreign markets, and this expands the breadth of the worldwide chain of commerce. The SEC is also attempting to expand its enforcement of the federal securities laws beyond the borders of the US. And, we lawyers use questions like jurisdiction. That is an important question because that's what we're talking about. The SEC is not asking that question. They're not asking questions like, can they charge someone, for example, if all the investors are in another country? Eric or Jeff, you had a situation where the SEC brings an enforcement action, not a single US investor, solely overseas. Is that a case they're going to bring? Yeah, they totally will. Again, I really don't want to make it seem like I'm bashing the SEC, but I am. And regrettably, they seem not to care much about optics. They are in a massive power grab right now. They're trying to expand their power to beyond their statutory authority. Releases by the SEC indicate that anybody who is either an early stage investor in private equity or recipient of investment funds is subject to their jurisdiction. The SEC is in an epic battle with FinCEN over anti-money laundering, Bank Secrecy Act SAR filing issues. So the SEC has a stated mission whenever they're dealing with offshore investors, or pardon me, offshore entities, either based offshore or based in the US with a business unit offshore, or vice versa. So their goal, this is their mandate basically. They are told that they have to protect investors, maintain fair and orderly and efficient markets, to facilitate capital formation. And here's the one that they don't mention all the time. They are also supposed to foster business growth and competition. To achieve those goals, the SEC requires companies, perhaps companies like the ones you all are affiliated with, to provide meaningful financial and other disclosure to the public. And it oversees the key participants in the chain of the purchase of a security. Disclosure is important in their statutory scheme, but it's more important in the articulation than it is in practice. Disclosure is really just the first step. The SEC brings lots of regulatory actions against individuals and companies violating federal laws. And it sounds counterintuitive, but not much is counterintuitive to the SEC. So let me ask you a question, and this is rhetorical again. The I mean, does the SEC have any jurisdiction over immigration issues? Jeff, I don't know if you've seen the EB-5 visa scams that are proliferating out there now. EB-5 visas are investor visas, basically. And they involve setting up a U.S. entity, and it's fairly complicated. Okay, so we got to come in here. There's some feedback, so maybe we should mute ourselves when we're not talking. Yeah, so I have I have some clients who live in India. They have a company. They got connected with an EB-5 visa promoter. $1 million from each of them, and promptly never returned their phone call. And these people really, when it comes down to it, they would tell me, listen, I don't care about the money. We just want a better opportunity for our kids. So they're playing on immigration issues. They're playing on people's desire to make their way in the world. And they really don't look at the consequences. So quickly, I'm going to tell you about some of these actions. We talked about EB-5 visas, we talked HB1 visas. Those all can be subject to the SEC's jurisdiction if packaged properly.
And Brent, I'll warn you, we've got just a couple minutes to make sure we sort of stick to schedule. Sorry for the warning.
No, beautiful. So Foreign Corrupt Practices Act violations are pretty common. Those are, I mean, the SEC has a specialized unit, but the Foreign Corrupt Practices Act is the statute that prevents companies doing business offshore from bribing foreign officials for government contracts or business. Public only hears about a few of them. Let me tell you about a few fact patterns that you won't see in the public record, but I personally participated in these, so this will give you an idea. Think about a company that sells consumer retail items. Obviously, they're made in China. A company typically must be in the manufacturing queue for that factory well before the holiday season if they want to have their widget in time for the holidays. So in early fall, the manager of a factory in China who manufactured my client's products called and said, if you want to be done in time for the holidays, you need to pay me a premium, or another company will take your slot at my factory. Should they pay? Is that a bribe? Here's the second fact pattern. And these both came from internal investigations that the board or audit committee engaged me to do. So a company doing business in Africa for many, many years just uncovered that a government revenue agent has skimmed 50% of everything they paid as tax. So what do? It's sort of unclear at this point. Now, what does this mean to you and your company? You need to be robust in compliance structure, whether you're a private company, whether you're venture-backed, or have your securities traded on a national exchange like NASDAQ or even the OTC Markets Group. Be aware that violations may be pursued against individuals, and in fact, they will be. Every case, every FCPA case in that slide involves charging not only the company, but also senior management and often compliance. Consider a chief compliance officer, make sure she has sufficient authority to head staff to monitor compliance as you expand offshore. Keep pace with the expansion. Keep written policies and procedures. It's not a one and done exercise. You got to continue to review and modify. Pay special attention to jurisdictions who are not friendly with the U.S. Those are the obvious players. Malaysia, India, Africa, Eastern Europe, Russia. And I think Eric, again, is going to talk a little more about that. So understand that raising money through a registered or exempt offering can subject you and your company to the SEC's jurisdiction. And finally, you really do need to seek good legal counsel who has the ability to work together as a team using their strengths to defend a client on multiple fronts. And I will leave it at that.
Great. Hannah, you want to turn over control the slides to me, and I'll advance to my slides. I'll skip through Brent's slides here. Give me a sec. All right. So my theme today is you need to remember one thing out of today's presentation, and only one thing, and that is internal controls and compliance. Virtually every case that I see in the United States involving foreign operations involves a failure to have good internal controls and good compliance over those foreign operations. It's oftentimes really easy for US-based companies to collect the money coming in from abroad and not to ask too many questions about what's happening in their foreign operations. You need to police, monitor, and make sure that what's happening in your overseas operations complies with US law and complies with the law of the jurisdiction. And I'm mostly going to cover today securities class actions and securities litigation. Brent covered regulatory stuff. So I'm going to start off by giving you some kind of data that comes from the Stanford Cornerstone Research statistics that are reported on their website every year. In 2020 so far, plaintiffs have filed about 182 new securities class actions in the first half of the year. That's about 1 in 21 S&P 500 companies. So, 4.8% of the entire S&P got sued in the first half of this year. So this is a robust industry, and they look for problems, and failure of internal controls is at the top of the list. 30% of those securities class actions that have been filed are against non-US companies. So you don't even have to be a US company, right? You just have to have shareholders in the United States, some connection with the United States. And 20% of those filings against non-US issuers had allegations related to cryptocurrency. So if your business is touching cryptocurrency, you're in a high-risk area. You're not only in a high-risk area in terms of securities class actions, you're in a high-risk regulatory area. There's a lot of activity going on right now with cryptocurrencies. Some big data points. There have been 298 securities class actions filed in the United States as of November 9th. 6 of those are in the 10th Circuit, which is basically where Utah sits in the West. 1 of those cases has been filed in Utah. Last year, there were 10 cases filed in the 10th Circuit, 5 in Utah. So we're a little less active this year, probably because of COVID. Most cases are filed in New York. There are all kinds of regulations, Brent touched on a few of these, that you need to be aware of in policing your overseas operations. You need to worry about the False Claims Act. If you're dealing with government contracts, you need to worry about the Foreign Corrupt Practices Act, which, as we know, bribery is kind of a standard modus of operandi for most of the world. Tax issues, accounting irregularities, fraud, GDPR in terms of privacy law. There are, depending on the type of business, there may be state statutes, like business opportunity statute, that come into play. Antitrust, anti-money laundering. There's all these things can touch your foreign operations and create giant risk for you in the United States. I wanted to give you just some examples of some cases that will give you a sense of some of the fact patterns. So this is a pretty old case, but it's one of the first cases I remember in Utah involving foreign operations. It involves Nature's Sunshine back in 2007. And really, they had some overseas operations that were engaged in some, allegedly bad conduct. And the company just had a lack of internal controls to actually know what was going on. And they did, some bad accounting, and they ran into some tax problems. And, ultimately they got sued. They also had some, investigations that went on by the government. And they wound up settling that case for $6 million. So, These kind of cases are not cheap. They're pretty expensive to litigate, and they're expensive to settle. And if you can't get rid of one on a motion to dismiss, you're in it for the long haul. So, these are Utah companies that have run into these issues that Brent and I are talking about. Another one from 2017 was USANA. USANA disclosed in its public filings that the company had been conducting an internal investigation of its China operations, focusing on compliance with the Foreign Corrupt Practices Act. I would say most of the securities cases I see that involve overseas operations, not all, do involve FCPA violations. And USANA was no different. They were investigating whether there was a violation of the FCPA in China. And of course, they disclosed that. Their stock fell. They got sued. So, oftentimes just the disclosure of the investigation triggers the lawsuit. And, they're off to the races. The regulators show up. It's every company's nightmare. A couple of years ago, I was talking to a good friend of mine who's general counsel of a public company here in Utah. And he said, the big weak spot of every public company, and I'm sure this is true for private companies as well, is compliance. He said, people don't want to allocate resources to it. They don't want to spend money on it. They don't want to really do the due diligence that's required to do it. They just, kind of turn a blind eye to foreign operations, and then something bubbles up to the surface and everybody panics. So, compliance, internal controls. So important, because it doesn't matter if it happens in Malaysia or Hong Kong and China. If you're a US company and those are your operations, you have a problem. Traffic monsoon is also a very interesting case. This just shows you how the reach of the arm of the regulators goes pretty far. So this case involved a Utah company run by this guy kind of out of his apartment in Cottonwood Heights. And 90% of the people who purchased this package were outside the US. So the customers weren't even really US customers. And it turned out that it was a Ponzi scheme. You would pay money that would create a little business that would result in people clicking on websites, and the more clicks, the more money that was generated. And it was really just a giant Ponzi scheme. The SEC came in, they shut the whole thing down, they got an injunction, they froze assets, and put the company out of business. But again, it had almost no nexus with the United States, other than the guy running it happened to live in Cottonwood Heights, Utah. Some other cases from the 10th Circuit, which I think are interesting. So Western Union, and I had no idea how big Western Union was, but they're a giant transfer of money. And so they have to comply with anti-money laundering statutes. And they got tagged in 2020 because about $632 million worth of their transfers had indicia of fraud and didn't get properly reported in terms of AML and SARS filings. That's less than 1% of the $85 billion they transfer. So, you think, okay, well, it's, 1%, but, $632 million in fraudulent transactions is something the government cares a lot about. And so, of course, when that came out that they had settled with both the Department of Justice, the Federal Trade Commission, and state AGs in 49 states for failure to comply with AML, of course, they got sued in a private securities class action as well. So, again, that's just compliance. If you're in the business of handling people's money, one obvious thing you've got to make sure you comply with are the anti-money laundering statutes that exist in this country and every country where you're also doing business. So again, indicative of the problems that US companies have doing business abroad. And here it's just 1% of their business, but 1%'s enough when you're talking about $632 million in transactions. Another case was interesting is the Petrubis case. And this involved kickbacks in order to get some contracts. It involved some famous money launderer named Youssef. And again, most of this took place abroad. It took place overseas. And yet, because there were securities in this company traded within New York, and the lawsuit was filed here, and the government investigation was done here, And this case settled for $3 billion. It's one of the largest US securities class action lawsuits ever. And again, it involved a lot of offshore activity, bribes and kickbacks and money laundering that didn't take place in the United States. And again, $3 billion out the door because of lack of compliance, lack of diligence, lack of internal controls. The CEMEX case is also very similar. It involved mostly things happening in Mexico in conjunction with building a new cement plant in a little town called Maceo in Northwest Colombia. And again, there were allegations of, kickbacks, bribes, special relationships, and all kinds of dirty dealings that took place offshore, not in the United States. And yet here we are. There's not only was a government investigation, but there was this securities class action filed in New York against them, and all just unnecessary if they had handled internal controls and compliance and complied with anti-bribery laws from the start. So I think there's this tendency that I see within companies in the United States is, well, if it happens abroad, we just kind of go, play dumb, put our hands over our ears and our eyes, and it's just not enough, because that conduct does bubble up. It does come to the attention of the public. It comes to the attention of regulators in other countries, and you're never going to avoid the problem. You got to tackle it up front in terms of how you deal with those types of issues. So the CEMEX case also resulted in an SEC and a DOJ investigation. And again, they mentioned in this opinion that the company discovered irregular payments and material weaknesses in internal control over financial reporting. Again, those are the two things I want to say that you take home today. You've got to manage the internal affairs of your foreign operations. You've got to pay attention to the laws that govern those foreign operations, and you've got to have compliance. That's all I want to say about that case. But let's look at some of the settlements that just in the last couple of years that involve foreign operations. Cobalt Energy settled their case for $173 million plus $43 million in attorney's fees. Walmart settled their bribery-related securities case for $160 million. Avon Products settled a FCPA-related security suit for $62 million. So these things can be gigantic, right? I mean, you can talk to Brent about the fines that the SEC and the disgorgement the SEC seeks in addition to these private payments, and it's equally as high, if not higher sometimes. So, the price of engaging in a lack of compliance and a lack of diligence can be way more than the profits that are gained from the foreign operations, and are a giant black eye and can sometimes just kill a company. So, compliance. CEOs, CFOs, general counsel, boards, you've got to all be proactive in ensuring compliance with the FCPA, with every regulation that applies to that business overseas. Compliance is a soft spot in most companies. I see it in the cases that I work on, where the foreign operations people just are not paying attention, and something comes back and bites the home office here in Utah. Compliance is the most underfunded part of management. It needs to go up as a priority. Compliance must be ongoing. It can't just be like set it up in the beginning and then don't do anything about it. You've got to constantly monitor it and make sure it's working. And I think in Utah, where we have so many people who go on church missions and learn languages, and we have a robust direct selling, multi-level marketing industry, that the risk here is particularly high. Utah is very comfortable doing business abroad, and we have the language skills and the type of business organizations that lend itself to that type of operation. And you see time and time again that industry has these very compliance issues that come back to bite them. Internal investigations, I do them, Brent does them, Jeff does them. They're really expensive. And then they have the bad part, particularly if you're publicly traded, if you've got to go share the bad facts that you discover with the regulators and the market. And so, it's just painful all the way around. There are also criminal risks, which means you'll hire someone like Jeff Corey, And there are also risks in foreign countries to pile on. You know, China right now is very active in terms of policing what's happening there, because there's a very large middle class in China. Over 350 million people in China are a middle class, and they have money to invest, and there really aren't good investment opportunities in China. So they put them into businesses that are operating in China or around the fringes of China. A word about the Caremark standard. This is, you know, I don't want to get too into the weeds on the law here, but Caremark is a famous case out of Delaware. And it came out, you know, a couple decades ago and was tectonic in terms of the business world. And then it got kind of watered down by the Delaware courts after a while. But basically, Caremark requires that if you're going to be liable for a breach of fiduciary duty, you have to have completely failed to have any internal control reporting mechanisms to police your operations. Well, a case came out this year called Hughes versus Ho, and it's kind of breathed new life into the Caremark standard. Everyone had kind of written off Caremark over the years and said that, you know, well, it's kind of dead. The courts don't really take it seriously anymore. They do now. And here's what the court in Caremark said, in the Hugh case said about Caremark. It said, in order to state a claim for breach of fiduciary duty, all that a plaintiff has to allege is that a company utterly failed to implement any reporting or information system or controls, or having implemented a system or controls, consciously failed to monitor or oversee its operations. Okay? So if you don't have internal controls over your foreign operations, or even if you have them, you consciously fail to monitor or oversee those internal controls, you're going to have a breach of fiduciary duty claim in your state court, as well as securities class actions in your federal court, as well as government investigations by the SEC, the DOJ, and whoever else has jurisdiction over it. And here, you know, the bad facts were that the audit committee here only got together sporadically, maybe once a year, maybe not. It abbreviated meetings, and they made almost no effort to comply with the federal securities laws. And so they just kind of, you know, didn't make a good faith effort to do their jobs. And that's really my takeaway here for you guys today. Make a good faith effort to make sure you know what's going on overseas, or you're going to hire people like Brent and Jeff and I to deal with the parade of horribles that's going to rain down on your company. So I'm not going to talk too much about these next three slides, other than to say that China is very active. I've put in the slides, and hopefully the World Trade Center will make those available to you all after this. But they're very active now in growing a regulatory body of regulations. And they're coming down on people from other countries who come in and do business in violation of their laws. The same is true in Hong Kong, and the same is true in Malaysia. So don't just worry about US regulatory risks, worry about the regulatory risks in the country in which you're operating as well. So I've tried to keep this on schedule so we can have a Q&A and a little dialogue going with you as well. So that's all I have to cover today. I do want to thank the World Trade Center for having the three of us come and speak to you today. I noticed in looking over the list of attendees that I have some friends in the audience. So hi to you guys. Thanks for coming and watching us today. Much appreciated on an early morning in the cold winter.
And thanks, Eric. And look, we've got a little time here. I've got a couple questions I want to ask you all. I also, again, want to encourage folks to type in questions. Any question is welcome. Look, a quick comment though, for those of you out in the audience, you know, one thing that you may be hearing in all this is kind of some of these crazy examples of illegal conduct or conduct that gets people in trouble. You may be thinking, well, my business is not a Ponzi scheme. And I just want to make a quick point. It takes very little to get on the radar of regulators, of the plaintiff's bar. You know, Eric mentioned, you know, the case where it was just 1% of the overall revenue was at issue. And so what we see in time and time again is well-run businesses, good businesses that mostly do things right, that occasionally have a bad business unit, and that's all it takes. And trust us, these problems, when they come up, are incredibly intrusive. Just to give you a quick example, in my last two cases, both cases have involved various agencies of the federal government demanding the personal cell phone data of CEOs, COOs. Just let that sink in for a second for all of you out there. You may think, oh, my business is not like this. We have had numerous clients say the same things, and then suddenly one day the federal government is demanding their personal cell phone data, which of course we try to fight against. But the reality is that is how intrusive and powerful these cases can be. And so with that said, I'm gonna throw one question out. We Eric, you're talking about compliance. This is really for Eric or Brent, but what are some examples of practical things that the audience, the businesses that are represented here today, should be doing right now to promote that compliance?
I'll just say you should know how your foreign offices are operating. You should know everything about them. If you see things that don't make sense, you need to find out why they don't make sense. If the operations that are taking place abroad seem to have financials that are different than your financials domestically, that's probably a red flag, right? So if your cost structure in an office overseas is much different, you probably ought to ask some questions about that. I think that frequently people will turn a blind eye and not ask questions. And so if something doesn't look normal compared to your domestic operations, you need to just jump on it and find out why.
And Brent, how about you, from some of your experience? What are some examples of things that maybe you've seen clients do wrong that as you could turn into a lesson for practical, policies to implement now?
Make sure that the U.S. books and records are maintained in the U.S. and understand that books and records maintained in any foreign business units will also be subject to the SEC's jurisdiction. So I worked for, well, the question I want to ask Eric is how important is D&O insurance in this process? But I'll tell you first that I worked on a case, the second largest case brought by the SEC, involving about $10 billion. That was the Stanford Financial Group case out of Texas, and I represented the senior investment officer. That, again, $10 billion Ponzi, but the international portion of this occurred because the majority of the purchasers of the fake CDs were in the Caribbean, Mexico, or get this, Libya. Now, you may ask yourself whether the principles of Islam prevent you from collecting interest. There are multiple issues there in these governments that are not secular. You also have to consider trying to audit the books and records of a client. They have to deal with foreign issues. I've got a CPA firm, a good regional firm. They have a NASDAQ traded company that has the majority of its operations in Russia. Well, not just Russia, also Tajikistan, Kazakhstan, and Cyprus. So you can imagine what the regulators, the SEC, and the Public Company Accounting Oversight Board are saying. They're saying, like, sorry, this is buying you an enforcement action. In the Stanford case, because they fleeced so many people, international people, when he was arrested, he was repeatedly beaten by Latin gangs in the detention facility in Texas. So there's this nasty component of the international side. They get word to their people incarcerated. Now, again, the D&O insurance question. Eric, how important is D&O insurance? I was the general counsel at a NASDAQ company, and that company actually lost its ability. They were sued so many times through shareholder actions, private shareholder actions, that their insurance carrier would not renew them. Eric, how important is D&O insurance?
Well, I think D&O insurance is great because it pays for your lawyer. It also creates an incentive. Most D&O insurance policies are what are called self-liquidating, which means every dollar spent on defense paying your lawyers reduces the amount that's available to settle the case. And so the plaintiff's bar knows that. So they work to try and resolve the cases earlier if you survive a motion to dismiss. Because of that dynamic, they don't want to spend too much money on the defense, so there's not much money left to pay out to settle a case. So they help bring down the dollar amount of settlements. They help fund it. They provide protection for the officers, directors. John Campos asked a question about, whether or not local D&O insurance would have served better than U.S.-based policies. Good question, John. I don't know. I haven't seen that issue come up. But D&O policies are critical, and I know the company Brent's talking about, and that not having D&O insurance is expensive.
Yeah,
I think we're
one little teeny comment here. In standard SEC settlements, in their boilerplate documents, they require you, if you are resolving the case, to represent that you will not be reimbursed, that you will not be indemnified for any costs or fees associated with that action. So sometimes the SEC will play that card, but sometimes they see that there's no other source and they can do a little horse trading.
I think with that, we are out of time. Aaron, everyone else, Hannah, I'll turn it over to you guys. I'll just say thank you one more time, and takeaway, like Eric said, compliance, because you never want to have to hire attorneys like us, frankly. So nothing against us. I love what we do for clients, but it's a lot easier to fix some of these things on the front end. So thank you, everyone.
Great. Thank you guys so much for showing us how to mitigate these risks and for helping Utah businesses. To everyone who joined the call today, we are recording this. We will be sending it out this afternoon along with the slides so you can review this information. I sent a survey to your inbox if you wouldn't mind just filling that out so we can make these events better in the future. Not that this wasn't great. Thank you guys for joining us this morning, and we hope you have a great rest of your day.